Okay, everybody. Good morning. Thanks for all of you that are in attendance here. We may have a couple other people that are going to jump on. Now I got to get rid of my note that says record. I've asked a friend of mine, Matthew, to come on board, Matthew Troiani. He's going to tell you a little bit about himself and the connection that actually he, Tom Campbell, and I have. But it's great to have everybody on here. This is, I think, a very important matter. As things go through, we may end up getting asked by other realtors, by the public, et cetera, things about this. And I'll let Matthew, give the introduction about himself and the topic. So Matthew, go for it.
Good morning. Thank you for that, Mark. My name is Matt Troiani. I'm Vice President of Professional Development and Chief Counsel for the Northern Virginia Association of Realtors. I see a lot of friendly names and faces on the call here today, but for those of you who don't know a little bit about my background, I've been practicing law for about 15 years now. I've been with NVAR for it'll be 4 years in August. But prior to coming to the association, I was in private practice. For the first several years, I was basically outside general counsel to financial institutions, international developers, builders, construction companies, HOAs, condominiums, large developments, that kind of thing. And as a part of that practice, interestingly enough, I actually did a fair amount of antitrust due diligence, investigations, and litigation, which is pertinent to what we're going to be talking about here today. Around the time that my son was born, though, I made a little bit of a pivot. I didn't want to work 90 hours a week anymore. And so I actually moved over into the settlement space. So I did commercial and residential settlements for about 6-7 years before coming over to the association. And during that time, I got to know a lot of realtors in the space and was even an affiliate member of NVAR before coming on as counsel. So, related to what we're talking about here today and the connection that I have to both Mark and Tom is actually my last name. My father was a classmate of theirs at the Naval Academy. In fact, I think I had been with NVAR for all of 3 weeks, and I was down to the Virginia Realtors Conference and met Tom. Tom recognized my name on my badge, and I took a picture and sent it over of the two of us, sent it over to my dad, who responded within like 15 seconds. He said, "Soup." So obviously, it's a very small world, but it's one that I'm grateful to be in and appreciate the opportunity to come and present to you all today.
Can I say something real quick, Matt?
Sure, please.
So the 35th Naval Academy reunion of our class at a golf tournament, I'm standing at the bar and Mark comes up to me and says, "Hey, are you still in real estate?" And I said, "Well, yeah, I am." He says, "Hey, just do me a favor." And I said, "Sure." He says, "Could you throw my son some business?" I said, "Sure, give me some information." And so I met with Matt, and the door opened because of his dad, but the door stayed open because of Matt. And when he had his own was working in settlements, he did a number of settlements for both me and a number of my agents. So I trust and value what he's about to say and his expertise. So please press on, Matt.
Well, thank you so much for that. And it was a pleasure, working with you back when I was doing that. But even since I've come over to NVAR, once we're all able to get back in person, I'd love to come down and visit your space in Occoquan again. That was a really cool spot. So preferably not on a morning where it was pouring down rain. So the reason why Mark asked me to come and talk a little bit about the antitrust lawsuit that is currently going on between the National Association of Realtors and the Department of Justice. Now, before I actually get into the specifics of that, I want to make sure that we're being very clear. We're not talking about the antitrust litigation that was filed by a bunch of consumers against the National Association and some of the largest real estate brokerages, which was filed over 2 years ago, believe it or not. The status of that, the plaintiffs in those cases are almost entirely sellers who brought a class action lawsuit trying to basically determine or get a court ruling saying that the entire notion of cooperative compensation, which underlies, the real estate industry, the code of ethics and the model MLS rules, to say that that was anti-competitive and that is a violation of antitrust law. Now, NAR has taken a very robust response to that. They feel that it is wrong on the facts, wrong on the law, and wrong on the economics. And they have defended that vigorously. Some of you might be thinking, well, it's been 2 years. Don't we have more resolution on that? When it comes to federal litigation, it's actually, 2 years is not a particularly long time. And some of it, of course, was delayed by the pandemic, but most federal courts are completely set up to operate remotely. And so the parties are in the middle of discovery right now, which is the process of exchanging documents, having people answer questions, admit to basic facts, depose potential witnesses and parties and things like that. So that's ongoing, but NAR is very vigorously defending that because the notion of cooperation underlies just about everything that we do as realtors through the association. So, and of particular note to, I think, Fathom in particular, as most of you probably know, and I would assume that veterans make up a fairly substantial portion of your client base, veteran borrowers who are using the VA loan program cannot pay anything towards for their agents to represent them. Not even those admin fees or flat fees or transaction fees, whatever you're calling them these days. And so could you imagine if, the notion of cooperative compensation was struck down? I think that the federal government would have to take a look at those underwriting guidelines, because otherwise they'd have to come out and admit that veterans are not entitled to their own representation unless they expect you all to work for free. So, so there's a lot of things going on in that I think we can put aside for now, because I don't think that there's a realistic chance of that going forward. What we're talking about here today was actually somewhat of a surprise for a lot of people who are in the industry, not so much to us in the association space. In November 19th of last year, I think it was a Friday, it was announced late in the day that the Department of Justice had filed a lawsuit, an antitrust lawsuit against the National Association of Realtors. But then the same day, it was also announced that there was a settlement agreement in place. Now, a lot of people are like, wait a second, how do you file a lawsuit and have a settlement the same day? Well, how that works is one of the interesting things about how antitrust litigation works, is that in the months running up to the filing of the lawsuit, the DOJ had already been reaching out to NAR to say, hey, look, we can go public with this and we can go to court, or we can handle this administratively behind the scenes, but we have some concerns about some of your practices and policies, and can we come to some kind of agreement? And if we do, then we'll file a lawsuit, we'll both make public announcements, and once we have the full settlement agreement in place, we'll get it entered as a court order, what's called a consent order, which means it's a settlement agreement with the force of law. If any party breaches it, you can automatically go back to the judge and say the other side's not doing what they're supposed to be doing. This is very common in antitrust practice. A lot of things happen behind the scenes, things are negotiated and resolved, and then the litigation proceeds. So on the same day, lawsuit is filed and the settlement agreement is announced. The problem, of course, is that the settlement agreement was basically an agreement to make an agreement. They agreed in principle on certain areas. NAR still takes the position that there is no wrongdoing, but they admitted that potentially they could clarify some of their policies to appease what the DOJ was looking at. And in the spirit of trying to ensure transparency and competitive practices in the marketplace, they said we'd be willing to look at these things. So for about the last 6 months, the NAR and DOJ have been negotiating language around that settlement agreement. What policies are going to be proposed to modify the Code of Ethics and the model MLS rules? Now, once those they come to an agreement on the actual language, then they're going to go to the judge and get the judge to approve the agreement. And then it's still subject to being approved by the NAR Board of Directors. Now, it is possible that the NAR Board of Directors might do a special meeting in the fall, but it's probably more likely that it'll be considered as a part of their ordinary board meeting at the annual conference in November. So we don't know the exact specific language of what is going to be changed, but we do know that it basically revolves around 4 separate points. They're going to they are going to update the MLS policies to require that the amount of the offered cooperative compensation be made publicly available. The idea here is so that if you are a buyer and you are a prospective buyer working with an agent, that you know approximately what the agent is going to be making based off of what is being offered on the listing agreement. Now, this does not, there is no set amount of what should be offered. You just have, we can't do that for antitrust reasons, but the idea here is that there is more transparency to the consumers. This is very consistent with how we teach best practices, even if this was not a required field. As I'm sure many of you know who work in our marketplace and use the NVAR forms, the exclusive right to represent buyer agreement has a compensation paragraph. And it says, in many instances, the seller may pay, but to the extent that the seller does not pay for the compensation, this is the agreed upon amount, usually as a percentage of the sales price, and the buyer will make up any difference between what the offer of cooperative compensation is and the agreed upon amount. So, you know, the idea here is that, you know, as a buyer's agent, you can have the conversation with your client. I will show you any property that you are interested in purchasing, but I'm just letting you know that if you've agreed to pay me X and they're offering Y, you get to make you buyer get to make the informed decision as to whether or not you want to write an offer on the property and potentially make up any difference there. That is informed consent, and that is perfectly okay. That is consistent with antitrust law. It's consistent with the code of ethics. It's consistent with the MLS policies. But the important thing here is they're trying to bolster the MLS rules to make sure that that practice is uniform across the country and there's greater transparency involved. Now, the interesting part of that is that on the flip side, even though that information is now publicly available, the model MLS rules may also be updated to make sure that you can't search by offered cooperative compensation. The idea here being is that part of an informed consent from your clients is making sure that they have all of the information in front of them. And so if you had a prospective buyer's agent that basically was steering the clients away from properties that they might be interested in just based off of maybe there was a lower offered cooperative compensation amount, that kind of steering practice is potentially violative of antitrust law. And so they, on one hand, they want to increase transparency, but they want to reduce the tools that certain realtors and agents might have in order to steer the clients away from properties and potentially artificially set a floor on the amount of cooperative compensation offered. So those are the first 2 potential changes. The third one is that they are going to potentially update the Code of Ethics Standard of Practice 12-1. Right now, we think it's relatively clear that there is a prohibition on agents representing buyers and tenants from promoting their services as free. Because even if you're being completely paid in the form of cooperative compensation, still technically speaking, your buyer or tenant is paying for part of that in the purchase price or the lease, the amount of the lease. And so they're going to be considering strengthening that language to make it abundantly clear. You cannot advertise your services as free and to make sure that it's clear that you're being paid in cooperative compensation, but that fundamentally is coming from either the sales price or the lease amount. And then 4 is the MLS policies may be amended to require, subject to seller's prior approval, that licensed real estate agents will have access to the lockbox of properties listed on the MLS, even if the agent does not subscribe to the MLS or is not a member of the association. Now, that may seem like kind of a big deal, but technically speaking, at least if you're in the Northern Virginia region, our regional lockbox rules already allow for that. We all allow one-day codes, which means that anybody with a license, subject to seller's approval, can come in, can be provided access to the property. Now, I think this is one of the main sticking points where we're seeing a delay in the ultimate settlement announcement, because the NAR is taking the position that the MLS policies or the association policies can still allow us to require that such agents who are non-members execute a lockbox agreement, be subject to the same security requirements, and pay a reasonable amount for such access. So, we're keeping a very close eye on this, because that's the one that's probably going to impact us as an association the most, because we write our own MLS rules. Most of the rest of this is a teaching point where there are tweaks to the policies. Bright MLS, our regional MLS, has already pretty much adopted most of these MLS policies anyway, so we're not going to see a huge change in our region on that. And then we'll keep an eye on what changes on the code of ethics. But the lockbox rules are one that we'll have to most closely keep an eye on to see if maybe there's an opportunity to, for the purposes of security, say that, okay, fine, you can have a code, you can have access to the property, but we can require that you come in and get an account and agree to abide by our rules. Because NVAR, we get a fair amount of code of ethics complaints. I mean, we're a fairly large association, but even for as big as we are, I mean, we get around 100 complaints a year. And probably about a third to 40% of them are based off of unauthorized access, either under the Century Lock rules or under Article 3 of the Code of Ethics. So we're keeping a very close eye on all of this. Right now, it's mostly just an awareness issue, but we feel confident that at some point NAR and the DOJ will collectively announce what they've agreed upon to change the rules. But then we're going to still have significant run-up time before they go live, because they still will need to be approved by the court and approved by the NAR Board of Directors.
Okay, great.
Yeah, that was a lot.
I appreciate it. Hey, we've gotten a couple of questions. Tim Shamblin, if you want to unmute, tell people who you are and ask your question, please.
Sure. Tim Shamblin. I'm president of the Blue Ridge Association of Realtors. So under the new the informed consent policy, if it goes through, would it just be the seller's agents, their commission, that would be required to be made public, or would would both buyers and sellers be made public, their commission?
Excellent question, Tim. Thank you for joining us. So they are very, very clear that the listing brokerage compensation will not be shown in the MLS. Because, you may think, oh, well, that's a transparency issue too, right? Mm-hmm. Except, if they were publishing both the listing agent or listing brokerage compensation and the cooperating brokerage compensation, that would probably have the effect of actually creating a floor on cooperative compensation, which would actually be anti-competitive in practice, and so it would be inconsistent with antitrust. So it is my understanding the DOJ is not pursuing requiring disclosure of the listing brokerage compensation, just the offer for cooperative compensation.
Okay, another quick question. Under the NVAR buyer's agreement, where the buyer's agent spells out how they're getting paid, typically we see a lot of agents use something like as per MLS or something along those lines. Is there something more appropriate that we currently should be seeing our agents put in there?
I would put in an amount. Either it'd be a flat dollar amount or a percentage of the sales price. Because first of all, if you put it in as per MLS, I'm sure many of you are aware the MLS only requires the offer of cooperative compensation to be $1. It can be any amount above that, but it basically is the dollar is the minimum amount. So if somebody decided, maybe it was a distressed property or something like that, and they put it in the MLS and they offered $1 cooperative compensation, is that what you all are willing to work for? You work really hard to do what you do, and if you've basically just agreed, you're taking that out of your hands. The other issue too is that what if it's an office exclusive or something like that and it never goes in the MLS? So my suggestion would be is have those conversations with your clients. This is everything that I'm going to do for you, and I'm going to get you into the property. This is the amount that we've agreed upon. Now, in many instances, it will be paid in the form of cooperative compensation, but I'm going to show you all the properties that you're interested in. And if there is a delta there between a difference between what we've agreed upon, then we can discuss that at that time as well. I mean, I know that from, conversations with thousands of agents that in many instances, if the difference between what you've agreed upon and your offer of cooperative compensation, you're not going to pursue that. But at least you have the ability to do so, and you can have the conversation with your clients up front on that. And at least you have the option.
So Matt, Tim, it's funny that you asked that question, because that's what I've told and directed my agents to do, is per MLS or as negotiated. Because again, if you end up going to a new home development, et cetera, and you know what's going on with some of the builders, I understand what you're saying, but I have yet to find a situation where you are that low. And the reason for my saying to do it that way is so that we do not get into that situation, especially with VA buyers that we have, where all of a sudden now we're telling them, or we're saying, okay, well, we can. That's the reason I recommended to my agents per MLS or as negotiated, to fit into those two different boxes where we are not. Because I have gotten conversations where people say, well, what if your compensation is lower than this? And having that conversation, I'm not keeping my agents from putting a number in there if that's what they want to do. But that was my reasoning for it. And I'm not sure why Tim brought that up, but that was going to be my question. So thanks.
It's a really important conversation, because the issue that we also have here, and this is, I'm going to be giving you a little bit more maybe like lawyer inside baseball kind of thing, is that, and I understand that the vast majority of this is, it's client management and maintenance, right? You're trying to keep them happy. Many of them might be initially resistant or hesitant to signing a brokerage agreement to begin with. We've heard that over and over again, even though it's required by state law.
Since 2012.
Yeah. But they'll say, well, hey, so-and-so down the street's been driving me around for 3 months looking at properties, and they haven't made me sign anything. And my response to that was, well, yeah, but then they're talking to you right now. So obviously they have not committed to that other party. And that other agent or realtor just ended up being an unpaid Uber driver for the last several months. But the other thing that's important to remember is that the brokerage agreement is a contract, and a contract requires a meeting of the minds as to all material terms. And so and I would say that compensation is a pretty material term to any contract. So one of the reasons why I also suggest at least putting a number in there, but indicating to the client that you would be willing to negotiate at a later date, is that if you put in an indeterminate amount up front, somebody could actually argue that you never had a meeting of the minds and you don't have a contract to begin with. Now, is that going to happen very often? Probably not. And technically speaking, it's an agency agreement that the client could pretty much terminate at any time anyway. So it's really more of an academic issue, but I also wouldn't want anybody in a position where they're trying to advocate to collect on a contract, but because they didn't agree to a determined amount up front, that somebody was able to kind of get off scot-free in a court by saying that there was no contract ratification. So that's the only reason, that's one of the main reasons why I suggest having a determined amount up front, but at the end of the day, it's mostly a risk management issue and a client maintenance issue. And we're realists about that kind of thing.
What other questions do people have? No other questions?
Either I did a really good job or everybody needs some more coffee.
Matt, would you put your email in the chat bar as well?
Absolutely. So I'm going to put my information in here. And then, of course, those of you who are members of the of any realtor association in the area, You can also submit a ticket on our legal hotline. Our legal hotline is primarily for NVAR members, of course, but we also opened up as a part of the pandemic response a regional realtor legal hotline, which is still open. I mean, we leave it up to our neighboring associations to promote it to the extent that they like to, but anybody who is a member of, Blue Ridge, Fredericksburg, Dulles, Greater Piedmont, and Prince William can also submit a ticket to us. We say 1 business day turnaround time, generally speaking. If you submit before 5 p.m., we'll get back to you same day.
He's pretty good about that, except for the fact, don't link yourself to me, otherwise it'll be a week.
Well, I'm going to call Mark first and be like, hey, what's the skinny on this? No.
All right. Anybody else? All right, Matt, thank you very much for coming and sharing that with us. I will probably call on you for a couple other things as things progress, but I appreciate it. And everybody, thank you for being here. I'm recording this. I will be putting this up on our Fathom, our Nova Agents Fathom closed site, as well as my broker site. So thanks everybody, and I appreciate everybody taking the time to join us. So thanks, and talk to you later.
Thanks for the invitation and the opportunity. Everybody stay safe, take care.
Right. Matt, thank you very much. I appreciate all that you did. Thank you. Tell your parents we said hi.
I will. Thank you. Take care.